It will be very dangerous to set out all the circumstances.
It should not be.
In fact,
Should not.
The constitution bench should not even attempt to do
No,
that,
no, no.
because we must respect the wisdom of the courts concerned.
The fact situation might differ.
Particularly in commercial matters, you must leave a certain degree of flexibility for courts to,
There are two or three things, my lord, why in my
modulate their decisions based on the situation, unless there's something really positively erroneous in the doctrine. Because ultimately you have to evolve the doctrine based on, the facts as they will emerge before succeeding benches.
B and A materializes, and B ultimately supplies the goods to C. Transaction, C is not at all aware what is going on between. One fine day, problems crop up. What do you intend to do? B says, I have taken up the issue with A. I have nothing. How am I concerned? Can C drag A into the arbitration?
Cannot. And the reason is simple. There is no defined legal relationship which came into existence.
So therefore, one or two instances, Mr. Kambata may also assist us. What could be a good example of a non-contractual legal relationship?
Therefore, my lord, in this very example, my lord, I'll point out. C wants some goods, my lord, and he believes that we will be able to supply it. Now, there is an exchange of correspondence between them that I want this description of goods.
You may develop it a little that in this confusion, there may be some correspondence between A and C at a later point.
Exactly, I'm coming to that.
Perhaps C may be able to drag A.
Correct. Exactly, that's what, my lord, in the example which your lordships have given, there does not come into existence any defined legal relationship between C and A. So, this doctrine cannot apply. But when C approaches B, that I want this particular description of goods, and only A will be able to supply, because this category of goods or description of goods only he manufactures. You are the retailer or a wholesaler. B approaches A, and there is an exchange of correspondence between three of them. A says, yes, I am agreeable if you enter into a contract as per this schedule of distribution or this schedule of supply. I will be able to supply every month 300 units, and I assure C that I'll supply it to B. Whatever is your financial arrangement, you have your financial arrangement. I can only say that I'll be able to supply. Now, a defined legal relationship comes into existence. He is not just a bystander, as my Lord Justice Roy, my Lord, very rightly, my Lord, points the word. He is a party to the negotiation. The very fulcrum of the contract is based on his agreement. He is not a signatory in the contract between B and C. But if a dispute arises because of his failure of supply, then he can't run away from the responsibility only on the ground that he is not a signatory to B and C. That's, my Lord, the contours of the document.
So again, a fact situation.
It will be very dangerous to set out all the circumstances.
It should not be.
In fact,
Should not.
The constitution bench should not even attempt to do
No,
that,
no, no.
because we must respect the wisdom of the courts concerned.
The fact situation might differ.
Particularly in commercial matters, you must leave a certain degree of flexibility for courts to,
There are two or three things, my lord, why in my
modulate their decisions based on the situation, unless there's something really positively erroneous in the doctrine. Because ultimately you have to evolve the doctrine based on, the facts as they will emerge before succeeding benches.
Therefore, my ultimate, the fulcrum of my argument is that your lordships would decide whether this doctrine is excluded from Indian law, and if not, whether the doctrine is applicable, and the fact situation in each case to be decided, my lord, either at the stage of section 8 or at the stage of section 11 or maybe at the stage of section 16. Somebody may raise a dispute, my lord. Section 11 comes when there is no agreement between the parties and we have to approach the Honorable Chief Justice or his Lordship's designate. But suppose there is a dispute between the two of us, we jointly go before an arbitral tribunal, joining C also. He can raise all these issues.
Actually, Mr. Solicitor, the last few lines, the last few words of section 7.1, which may have arisen or which may arise between them in respect of a defined legal relationship, without contractual or not. These words define what is the origin of the dispute or what is the source of the dispute. The dispute, there has to be an arbitration agreement. An arbitration agreement is an agreement to submit disputes which have already arisen or which may arise in future. There is no dispute today, or which may arise in future.
But existence of relationship.
But which may arise between them and in respect of a defined legal relationship, whether contractual or not. So these words, in respect of a defined legal relationship, whether contractual or not, refer to the source
Of dispute
or
or the contract.
The dispute must arise either through a contract or it may arise through a legal relationship other than a contract.
Yeah.
So, for instance, I'll give you an example. It may sound a little, I just concocted it here. Suppose a builder has a large tract of land. He carves out plots and assigns plot A to A, plot B to B, plot C to C, plot D to D, plot E to E. Now, there is no contractual relationship between A, B, C, D, and E.
Correct.
Right?
Complete bystanders.
The contractual relationship is only between A and the builder and A, the builder and B, the builder and C. But suppose in future a dispute arises between the individual purchasers over the sharing of common amenities or the sharing of a common source of water or a green area, so on and so forth. There might be then an arbitration agreement which says that any dispute between them, A, B, C, D, and E, will be arbitrable. Because then there is no contractual relationship between A, B, C, D, and E unless they've entered into a cooperative society or a condominium. But by virtue of the fact that they are neighbors, there is an element of a legal relationship, what you shall do and what you will not do to a neighbor. Okay, so therefore that is a sort of a dispute which may be an arbitrable dispute in the future. There is no contractual.
But in this section 7 doesn't talk about arbitration contract. So it is talking about arbitration agreement. Agreement is defined under the Contract Act, where there is an offer and an acceptance. Contract is defined as an agreement which is enforceable in law. So there are two legal relationships. One is a legal relationship of a contract, and another one is a legal relationship of an agreement. Contract Act contemplates entire regime with respect to how to enforce a contract and also how to enforce an agreement. So far as agreements are concerned, 68 onwards talk about certain relationships resembling those created by contracts. So therefore, those aspects which have not emerged into contracts can also be subject matter of an arbitration. So therefore, it's a holistic.
Yes.
An arbitration can be with respect to enforcement of contracts. It can be with respect to, that is more or less similar to specific performances.
Correct.
So which is also, though it's not a contract, nevertheless, it has come within the fold of an arbitration agreement. That is how it takes within.
Yes. Now,
apropos, to take it a little further, what Arbitration Act is talking about when it's speaking under section 7 of arbitration agreement, there are three inviolables there. First and foremostly, written agreement is necessary, not contract, written agreement. Second is parties are necessary, but these two are not frozen. 4B gives meaning to it, saying parties as well as legal relationship is inferable from what is defined as the record of agreement. So
Not
what we have,
agreement
therefore,
in
what
writing,
the
but
code
record.
does- What the code does is, code has in every case, look into the existence of parties. That's also inferable from the record of agreement. Court will also have to see the legal relationship, which is also inferable from the record of agreement. So we will have actually a written agreement, not in terms specified as A
An
and
act
B.
of agreeing.
A and B, but whether A, B, C, or D are inferable from the record of the agreement. And similarly, the relationship is also inferable from the record of agreement. So, really speaking, coming to the question, what is
What
the
are we
Constitution
deciding?
bench supposed to do? It's already there. Why this
But
reference?
the argument was
We can
that
perhaps
the
discharge the
doctrine,
reference.
the argument was that there is an exclusion of the doctrine.
There's no
There
specific
is the
subject to
judgment
hearing,
which is
Mr. Rai.
staring in our face.
Lord, another thing. Lord,
There's no
apropos, my
specific
lord,
exclusion, as you rightly said.
Lord, apropos, my lord Justice, my lord.
I'll give you another example of a legal relationship which was not contractual, which can be subjected to arbitration. Suppose there are 5 brothers and sisters. They have a common property. They want a partition of the property. They want their shares to be identified, or the shares are given in law, but they want a division by metes and bounds. There's so many arbitrations which take place. There's no contractual relationship between the members of a family. If they are partners, there's a contractual relationship.
So, Lord,
Because then there's a partnership.
your lordship, sir.
But if there is a non-partnership dispute between, say, members of a family, you can submit that dispute to arbitration. What is excluded, of course, is just that, just as Ravindran said, where it's, in rem, then you can't.
That's correct.
So you can't, it's a will.
Indo.
The will operates in rem. Once will is probated, probate can't be referred to arbitration.
So it's in rem.
Or that's right. Or something which is determinative of legal status, like the paternity of a child. That you can't refer to arbitration. As just Ravindran carved out, admiralty.
1, 2, 3. My lord, 3 areas are out of. Lord, now, apropos, my lord, your lordship, my lord, the
Therefore, when you agree to an arbitration, the dispute may not emanate from a contract at all. It may emanate entirely from an area other than a contract. That's right.
Look, kindly, my lord, taste your lordship's example, my lord, again for 7-1. Again for 7-1, my lord. Kindly, I'm sorry. My lord, Justice Narasimha.
No, nothing, sorry.
No, I'll do that.
Yes, Mr. Mehta. So,
Yes, Lord, taking your lordship's example, just my lord, then I'll move on to the other point. Lord, kindly see 7-1 in a scenario which my lord, the Chief Justice of India, matter of fact, discovery, chair, and etc. Your lordships have examined the fact-specific situations. In fact, it never required a reference. I'll assist your lordship. Kindly come to 7-1 again, my lord, in the context of your lordship's illustration that a builder having a separate agreement contract with A, separate with B, separate with C, and some dispute between A, B, C, D. Now, please see, it is in this part, arbitration agreement means an agreement by the parties. So, builder can't be roped in unless there is something to suggest that he also has acquired certain responsibilities.
way that dispute,
And it should be resulting into some kind of a defined legal relationship, which may be contractual, which may not be contractual, which may be, my lord, arising in case of, my lord, illustration like this nature, my lord, easement. Whatever, my lord, I'm not giving examples. My lord, now I'll move forward. My lord, there was a reference that there is a Law Commission's report. Lord, 246th Law Commission report. I'll finish it in 5 minutes, this Law Commission report one. Lord, there was a suggestion. There were 2 suggestions. Lord, page 7. A. The Law Commission merely recommended amendment to section 21H, that is parties, and not to section 7 of the Act. In other words, even the Law Commission did not find that without amending both section 21H and 7, Group of Companies Doctrine cannot be statutorily recognized. They never said that you amend section 7. B, the said definition was not required to be mandated as the suggested definition. If read, my lord, your lordships can skip, my lord, I have reproduced and possibly somebody has read, my lord, 61 to 64 of Law Commission's report before your lordship. But C, when section 7 provides for a permissible dispute resolution, even amongst the third party, even if they are not contractually bound with each other, mere enlarging the scope of the term party to add person claiming through or under such party, that was the amendment suggested, may perhaps restrict the wider meaning of section 7. And therefore, my lord, maybe that is not accepted. Lord, I hope, Lord, I am able to make myself clear. Section 7 is very widely worded so as to include every kind of legal relationship if there is an agreement shown to exist, whether agreement is contractual, not contractual, irrespective of that. Now, if the definition of section 2(1)(h) is amended, it would restrict that either person claiming through him. So possibly that can be the reason it was not, my lord, amended.